The Supreme Court chamber felt tense as Representative Jasmine Crockett stood before the 9 justices. Her dark blue suit stood out against the dark wood of the podium. TV cameras zoomed in as Justice Clarence Thomas leaned forward, his face serious. Then something amazing happened that shocked everyone in the legal world. "I've read your brief a few times," Representative Thomas started, his deep voice cutting through the room. "And I have to say, your understanding of basic law seems pretty weak. You really need to go back and learn the basics before appearing before this court." The room fell silent. Reporters stopped typing. The rest of the justices shifted in their seats. But Representative Crockett didn't flinch. Instead, her eyes narrowed a bit as she gripped her legal pad tighter and reached for a binder her assistant had prepared. "Justice Thomas," she began, her voice steady despite the direct attack. "I appreciate your concern about my legal knowledge, but in the next 5 minutes, I'm going to explain exactly why your assessment is not only wrong, but also dangerously misleading to the American people." No one could have predicted what happened next. Inside the binder was proof that would not just defend her legal skills, but would also turn Justice Thomas's own court history against him, leaving the veteran judge speechless for maybe the first time in his 30-year career. But before we get into this incredible showdown, please like this video and subscribe to our channel for more important government analysis you won't find anywhere else. Hit that notification bell to stay updated on the most dramatic moments in American politics. Judge Clarence Thomas sat in his usual spot, middle right on the platform. He's been on the Supreme Court for over 30 years. At 75, Thomas has become more outspoken lately. He wasn't the type to go years without asking a question during arguments. Now he's a bold conservative, not scared to challenge anyone who doesn't respect his originalist view of the Constitution. "The Constitution means what it meant when it was written," he said in a recent opinion, "not what some liberal wants it to mean now." For Thomas, this case wasn't just another one. It was a fight for the core values he's defended his whole career as a judge. The voting rights case before the court had big implications for future elections, and Thomas seemed ready for a fight. Across from him was Representative Jasmine Crockett, a 42-year-old former civil rights lawyer from Dallas. Only in her second term, Crockett has become known in progressive politics. Her legal background includes defending protesters, fighting voter suppression, and winning tough civil rights cases in Texas. Before Congress, she made a name for herself as a strong courtroom presence who could explain complicated legal arguments to juries. Crockett was asked to present arguments because of her expertise on voting rights in the South. She knew she was speaking for many voters whose access to the ballot box was at stake. "This is personal for me," she told her staff while preparing. "I've seen voters turned away, polling places closed, and communities silenced. Judge Thomas might see this as a basic theory, but I've seen what happens in real life." The stakes were super high. This lawsuit, Richardson versus Ballot Board of Georgia, was about these new rules for voter IDs. The thing is, they could stop tons of people from voting, and it would probably hit minority groups the hardest. It looked like the conservative judges, the ones who listened to Thomas, were going to say the rules were just common sense to keep elections safe. The other judges, the more liberal ones, thought it was a sneaky way to keep people from voting. You could feel the tension in the room before they even started talking. Some of the legal experts watching said it seemed like it would be a 5-4 split, with Thomas writing the main opinion, which could change voting rights in the U.S. for years. When Thomas made that dig, it wasn't just a jab. It was like he wanted to trash Crockett's case and her reputation as a legal mind. By questioning if she even knew the basics, he wanted to screw with everything she said to the court, but Thomas didn't know that Crockett was ready for him. Her team had watched how he gets more and more aggressive, so they knew what to expect. She had a file with something that was going to make this case one that law schools would talk about for years. The room went quiet while Crockett got ready to speak. Judge Elena Kagan looked at Thomas like, "Really?" Judge Ketanji Brown Jackson sat up straighter, all of a sudden paying way more attention. Everyone could feel something big was about to happen. "Judge Thomas," Crockett began, her voice getting stronger, "I want to answer your worry about my legal skills by talking about what's at the heart of this case." Thomas leaned back, smirking. "Go ahead, legislator, teach us." He was dripping with arrogance. Some reporters in the press area looked at each other. People in legal circles knew Thomas could be a jerk, but he almost never went this hard on a lawyer in court. The 14th Amendment's Equal Protection Clause and the 15th Amendment's protection of voting rights, no matter your race, are the basis of my argument. Crockett started, laying out her case. The Georgia law in question creates problems that unfairly hit certain groups, as the data on page 34 of my brief shows. Thomas cut her off. I know what the amendments say. What you don't get is that these amendments don't promise convenience. They promise everyone is treated the same way under the law, and this Georgia rule treats all voters the same. Several conservative judges nodded in agreement. Judge Samuel Alito leaned toward his speaker. To build on Judge Thomas's point, where in the Constitution does it say you get to vote without showing ID? The questions were coming hard and fast. Crockett stood her ground, but the court conservatives seemed intent on shooting down her argument before she could finish. Actually, Judge Alito, the Constitution's protections mean that supposedly fair rules can't create unfair results. The data clearly shows information can be changed. What can't be changed is the wording of the Constitution, which says nothing about how states check voters. Maybe that's the problem I was talking about before. A few gasps came from the audience. Thomas had doubled down on his attack, basically accusing Crockett of messing with the facts. Chief Judge John Roberts shifted in his seat, worried that the exchange was getting too personal. Crockett took a deep breath. Her aide quietly slid another paper to her. It contained numbers from 3 separate research groups confirming that the Georgia law unfairly impacted certain groups. But she knew that facts alone wouldn't be enough to counter Thomas's dismissive attitude. Judge Sonia Sotomayor tried to get things back on track. Let's talk about the evidence in the brief about access problems in rural Georgia areas. But Thomas, being polite, interrupted Sotomayor. He didn't look away from Crockett. I think we need to fix this central misunderstanding of core principles before we dig into local details. The legislator seems to be pushing for judging based on the results she wants, not on what the Constitution actually says. The pressure in the room was building. What started as arguments in a big voting rights case had become a direct challenge to Crockett's legal credibility. Some people noticed that Thomas seemed really focused on discrediting Crockett personally. Rather than just disagreeing with her legal points, Crockett glanced down at her notes, then up at the clock. She didn't have much time left, and Thomas's interruptions had wasted precious moments. She needed to switch things up, fast. Judge Thomas, she said, her voice calm but firm. You've questioned my understanding of basic values several times now. I think it's best to address your concerns head-on by looking at how these values have been used in the past by this court. She opened the binder her team had put together and took out a document that her lead researcher had spent many late nights on. It held something that would change the whole course of the arguments. To get ready for today's arguments, my team and I looked at every voting rights ruling you've made or been involved in since you became a judge in 1991. We weren't looking for political views, but for consistency and basic reasoning. Thomas's expression changed slightly. The other judges leaned forward, suddenly curious about where Crockett was going with this unusual approach. What we found, Crockett continued, her confidence growing, was a pattern that I want to talk about in regard to the case we're discussing today. Especially important is your concurring opinion in Shelby County versus Holder, where you argued that Section 5 of the Voting Rights Act was unconstitutional from the start, not just as it's being used now. Thomas's mouth tightened. Crockett was directly challenging his most debated voting rights position. I have the data here, Crockett said, holding up several pages of neatly organized charts. And what it shows about the consistency of basic reasoning might shock everyone in this room. The room went silent. Even the reporters stopped what they were doing. Judge Thomas's earlier insults vanished, replaced by intense focus on the papers Crockett held. Congresswoman, Chief Judge Roberts said, checking the timer, "You have 10 minutes left." Crockett nodded. "Thanks, Mr. Chief Judge. That's plenty of time to show why Judge Thomas is wrong about my legal understanding and to point out a pattern this court needs to see." Thomas leaned forward, hands clasped tightly. This went beyond a simple legal argument. Crockett was about to challenge not just Thomas's view of her skills, but his entire record on the court for the past 30 years. It was set to be a huge moment in Supreme Court history. Jasmine Crockett stood up straight and confidently approached. The room was completely silent. No papers shuffling, no whispers from the assistants. Even the press team sat still. "Judge Thomas," Crockett began, her voice clear and steady, "you suggested my understanding of basic law is simple. I'd like to respond by looking at your own use of basic values in voting rights cases." She put a paper on the stand, turning it so the judges could see the detailed timeline. This looks at your decisions on voting rights cases from 1991 to today. What it reveals is a pattern hard to reconcile with the originalist values you claim to always use. Judge Thomas's face didn't change, but his fingers tapped lightly on the desk, a rare sign of stress from the normally calm judge. Back in 2008, in Crawford versus Marion County, you sided with Indiana's voter ID law, citing the state's interest in fair elections, even though there wasn't much proof of actual fraud. But then in 2013, in Arizona versus Intertribal Council, you argued that state power should trump national election rules, basically flipping your earlier stance on national versus state authority. Crockett moved on to the next point. But this next switch is really telling, she said, her voice gaining strength. In Shelby County versus Holder, you said that the Voting Rights Act's pre-clearance requirement was unconstitutional because current data didn't justify treating states differently based on past discrimination. She paused, looking directly at Thomas. Yet just last session in Allen versus Milligan, you dismissed current data showing ongoing bias, arguing that the Voting Rights Act couldn't constitutionally address racial gerrymandering at all. So you're saying that neither past nor present data matters, which goes against your own reasoning in Shelby County. A murmur went through the courtroom. Judge Kagan leaned forward, curious. Judge Kavanaugh glanced sideways at Thomas. These contradictions reveal something important, Crockett continued, her pace quickening. The problem isn't the Constitution itself, which hasn't changed. It's the selective application of principles to get the outcome you want. Thomas's face darkened. He started to lean toward his speaker, but Chief Judge Roberts raised a hand slightly, a silent signal not to interrupt during allotted time. But I'm not just here to point fingers, Crockett went on. I'm here to safeguard the right to vote, and that's why I want to connect this directly to our case. She held up a blue binder. This contains sworn statements from 173 Georgia voters who were wrongly kept from voting, even though they were eligible residents. One of them is Mrs. Dorothy Wilson, an 86-year-old woman who has voted in every election since 1956, but was turned away because her married name on her ID didn't match her maiden name on old voter rolls. Crockett showed a photo of an old African-American woman holding her voter registration card and driver's license. Mrs. Wilson was born when segregation laws were in place, Judge Thomas. She marched with Dr. King. Yet, in 2024, a poll worker told her she couldn't vote because of a clerical error. Thomas's face changed a bit. You could almost see something getting through his judge's mask. The Constitution's important, Judge Thomas, and we agree on that. The 15th Amendment clearly says the right to vote can't be denied based on race. So, when a law ends up preventing Mrs. Wilson and thousands like her from voting, while white voters don't face similar problems. That's exactly what the people who wrote the Constitution wanted to prevent. I could turn and talk to the whole court. My understanding of basic law isn't just book smarts. It comes from seeing how it's really used for people in the USA. The Constitution wasn't written to be some abstract idea. It was written to protect folks like Mrs. Wilson. He deliberately put the statement on the stand. And honestly, Judge Thomas, pretending that seemingly fair laws with obviously unfair results somehow respect the Constitution's words and meaning. Well, that is a bit much. The courtroom was silent. Several judges scribbled notes. Judge Jackson had a tiny smile. Judge Alito looked uncomfortable. Thomas leaned forward, losing his earlier dismissive attitude. "Lawyer," he said, his tone different, "are you saying I've been inconsistent? Couldn't the same thinking show changes in your own legal views over time?" That was a real question, not an accusation, the kind you ask respected legal minds. Crockett nodded politely. "A fair question, Judge Thomas. My views have changed as I've seen how these laws are used in the real world. The difference is, I don't claim to be strictly following the original meaning as the base of my legal way. I admit that seeing Mrs. Wilson turned away from her polling place changes how I get what the 15th Amendment protects." She pointed to what was written. "This isn't just talk. We're talking about folks in the U.S. being denied their basic right. If standing up for their right to vote makes my legal understanding basic, then maybe this court needs more of that kind of thinking." Thomas leaned back hard to read, but the mocking look was gone. For maybe the first time ever, he seemed speechless. Chief Judge Roberts said, "Your time is up, Representative Crockett." "Thank you." As Crockett gathered her things, something odd happened. Judge Ketanji Brown Jackson gave a small nod her way, a quiet but clear sign that everyone noticed. Even weirder, Judge Kavanaugh leaned over to whisper something to Judge Barrett. And they both looked like they were really thinking about things instead of disagreeing. The lawyer for Georgia walked up to argue back, but the whole vibe had shifted. The confident attitude the judges had before was now replaced with a hint of uncertainty. What started as Thomas trying to make Crockett look like she didn't know the law had turned into something else entirely. A representative hadn't just stood her ground, but actually challenged one of the most judges in the U.S. on his own turf, using his own words against him. As Crockett sat down, reporters were already rushing out to file their stories. No matter what the decision ended up being, what just happened was the story. And it was about to explode all over the news. Almost the second the Supreme Court meeting ended, social media went wild. One news legal reporter posted, "Wow, Reverend Crockett flips the script on Judge Thomas after he questions her legal knowledge. The most direct challenge to a sitting judge I've seen in 20 years of covering the court." When Crockett left the Supreme Court building, her phone blew up with notifications. Crockett versus Thomas and Basic Mr. Thomas were already trending nationwide. TV channels cut into their schedules to cover what analysts called an epic showdown at the nation's high court. Reporters swarmed her on the steps outside. "Legislator, were you prepared for Judge Thomas to question your legal credentials?" one shouted. Crockett paused, choosing her words carefully. "I came prepared to defend voting rights, not my resume. But yeah, my team expected tough questions and we were ready for them." Another reporter yelled, "Do you think your exchange with Judge Thomas will affect the final vote?" "That's not for me to say," Crockett replied diplomatically. "Supreme Court justices base their decisions on core principles, not just arguments. I just presented the facts as I see them." But behind her careful public response, Crockett's team knew something big had happened. Later that day, in her legislative office, her lead legal advisor couldn't contain his excitement. "The assistant I talked to said Thomas was totally silent during the meeting," he told Crockett. "That never happens. He always leads with his opinion on voting lawsuits." By nightfall, clips of the hearing had gone viral. The moment when Crockett laid out Thomas's conflicting rulings had been viewed over 7 million times. Law professors were already assigning the transcript as required reading. Experts across the political spectrum weighed in, many acknowledging the effectiveness of Crockett's approach, regardless of their views on the case itself. Harvard law professor Lawrence Tribe tweeted, "Whether you agree with her position or not, Crockett displayed masterful legal advocacy today. Using a judge's own words to challenge his consistency is top-tier lawyering." Conservative legal analyst Jonathan Turley wrote in his blog, "While I disagree with her conclusions, Crockett's systematic presentation of Thomas's voting rights jurisprudence reveals a troubling pattern that originalists must address seriously." In newsrooms across the country, producers scrambled to book experts who could explain the significance of the exchange. A conservative network gathered a panel of traditional legal scholars, some defending Thomas, others acknowledging Crockett's skill. "She didn't attack him personally," one analyst noted. "She attacked the consistency of his judicial approach using his own rulings. That's fair game, and frankly, it was brilliantly done." On a progressive network, legal commentator Neil Katyal, who had argued many cases before the Supreme Court, couldn't hide his amazement. "What we saw today was remarkable. Supreme Court advocates spend their careers avoiding direct challenges to justices. Crockett not only faced Judge Thomas head-on, she systematically exposed contradictions in his judicial record that he couldn't easily dismiss." The White House carefully avoided direct comment, with the press secretary stating only that the president believes strong legal debate strengthens our republic. Behind the scenes, however, sources reported that multiple calls had been made to Crockett's office from high-level government officials expressing private support. By the next morning, the story dominated headlines nationwide. In rare Supreme Court clash, legislator challenges Judge Thomas's consistency on voting rights, read the New York publication's headline. The Financial Journal went with, "Representative's systematic response to Thomas raises questions about court consistency." Law schools reported a surge in applications mentioning an interest in voting rights law. Several civil liberties groups saw significant increases in donations, with many donors specifically citing Crockett's defense of Mrs. Wilson and others like her. For Crockett, the consequences brought both opportunity and challenges. Interview requests flooded in from every major network. Legal and political conferences sought her as a keynote speaker. Rumors began circulating that she was being considered for leadership roles within House Democrats' judicial strategy teams. But with attention came scrutiny. Conservative media began digging into her legal career, looking for inconsistencies or mistakes. Security concerns prompted law enforcement to increase patrols near her office after several threatening messages appeared online. 3 days after the hearing, as speculation about the court's final decision reached fever pitch, Crockett spoke to a group of law students at Howard Institution Law School. "What happened in that courtroom wasn't about me or Judge Thomas," she told the packed room. "It was about whether our legal system has the courage to look beyond theory to see how laws actually affect real people. It was about whether the Constitution is a living document that protects all United States citizens or just those with certain kinds of privilege." A student raised her hand during the compe. "Do you think your exchange will change how Judge Thomas views voting rights cases?" Crockett smiled thoughtfully. "I don't expect to change Judge Thomas's judicial philosophy, but I do hope our exchange forces everyone on the court to confront the gap between legal theory and lived reality. Mrs. Wilson doesn't care about originalism or living constitutionalism. She cares about exercising her right to vote." Meanwhile, inside the Supreme Court, the justices were debating. According to sources who spoke anonymously to trusted court reporters, the initial vote had indeed been 5-4 along ideological lines, with Thomas assigned to write the main opinion upholding Georgia's strict identification mandates. But something unusual happened during the drafting process. Thomas's initial draft reportedly made no mention of the statistical evidence Crockett had presented, focusing instead on abstract legal principles. Judge Barrett, sources claimed, sent a private memo questioning whether the opinion adequately addressed the documented unequal impact on minority voters. Judge Kavanaugh reportedly raised concerns about the public perception of ignoring the sworn testimonies of affected voters like Mrs. Wilson. When the court's decision was finally announced 2 months later, legal observers were stunned. In a surprise 6-3 ruling, the court struck down key parts of Georgia's voter identification law while upholding others, a detailed decision that acknowledged both security concerns and access problems. Most surprising was the main opinion, written by Chief Judge Roberts, but joined by Thomas, along with the court's 3 progressive justices and judges Barrett and Kavanaugh. The opinion specifically referenced convincing evidence that certain parts of the law create substantial and unnecessary burdens on voting that fall unequally on certain groups, in a rare agreeing opinion spanning just one section. Judge Thomas wrote, "While I maintain that the Constitution's wording supplies the final direction in these cases, I recognize that loyal usage of foundational values demands cautious assessment of their impacts on residents, such as those who supplied accounts in this lawsuit." The 15th Amendment's ban on denying the privilege to ballot due to ethnicity applies not just to regulations that clearly reference ethnicity, but also to those that accomplish the identical banned outcome through more discreet methods. The proof delivered in this lawsuit shows that certain parts of the Georgia regulation drop into this latter group. Legal experts immediately noticed the notable shift from Thomas's previous positions, a shift that many linked directly to his exchange with Crockett. 6 months later, when Crockett announced the launch of a fresh voting rights organization concentrated on gathering and delivering information on ballot entry nationwide, contributions flooded in from across the nation. The organization's initial employment was of permanent personnel dedicated to assisting individuals like Mrs. Wilson manage ballot mandates and surmount managerial obstacles. At the organization's launch occasion, Crockett spoke about the lasting impact of her Supreme Court clash. Some individuals labeled it a triumph when Judge Thomas participated in that primary judgment. But the genuine triumph belongs to Mrs. Wilson and the thousands similar to her who will now be capable to ballot without unneeded hurdles. That's not a factional success. It's a United States success. As the midterm elections approached, voter registration drives across Georgia reported record numbers of members, many specifically citing the Crockett lawsuit as their incentive for involvement. And in a tiny church basement in rural Georgia, 87-year-old Dorothy Wilson spoke to a group of first-time voters, clutching her newly issued voter identification card. "I've been participating since Eisenhower was president," she told them, her voice strong despite her age. And thanks to what happened in that courtroom, I'll keep participating as long as the good Lord keeps me on this earth. The clash that commenced with Judge Thomas ridiculing a legislator's legal abilities had converted into something much more important, an instance that prompted America that behind every juridical concept and foundational discussion are actual individuals whose core privileges depend in the equilibrium. For Crockett, the heritage wasn't about succeeding a claim with a highest tribunal judge. It was about guaranteeing that the Charter's assurances were maintained for every United States citizen, irrespective of where they resided or what identification they possessed. As this account persists to form United States juridical and governmental records, remember to approve and join our channel for more analysis of the instances that characterize our republic. Hit it, that alert icon, to be the first to learn about major advancements in ballot privileges lawsuits countrywide, and submit a remark below expressing your thoughts on this historic clash between Judge Thomas and Legislator Crockett. Your tone counts in this continuing discussion about the destiny of United States Republic.